excellent panelists who will be joining me here. Dave Levine. Dave Levine is professor of law at the Elon University School of Law. He's also an affiliate scholar at the Center for Internet Technology at Stanford Law School. And he's a fellow at the University of North Carolina Center for Information Technology and Public Life. He is widely renowned as a scholar of trade secret. Trade secret might be the most important area of law that most people who are not lawyers have not heard of. It's an incredibly important area of law. And Dave is at the forefront, particularly in the area of AI. In the area of AI, trade secret is probably the dominant intellectual property regime that is being used in this area. Dave's work has been long recognized as important and part of the conversation. So please join me in welcoming Dave Levine to this fireside chat. So, yes. Well, welcome, Dave. So I've heard that we've talked about technology impacting the labor market, and I've heard that you've had some personal experience with that and in your life. Can you tell us a little bit more about that?
Thanks, Harry. And thanks again for my students know that I don't need microphones because I'm a loud New Yorker, but I'll attempt to use the mic and not break the mic through sound problems. Thank you for having me here. Thank you to everyone who put this together. My wife's an alum of University of Colorado, and she cannot be here because we have children, but she would be here otherwise, and so I'm excited to be back here. Yeah, I think about this from a very personal perspective. My undergrad degree is in labor relations from Cornell, and I thought a lot about the workplace growing up. Both of my parents were in the publishing business. My mother is a book jacket designer and did that for decades. My father was in book manufacturing. And I watched as I was growing up, and this is in the 70s and 80s and into the early 90s, the trajectory of technology. In the case of book jacket design, my mother had to learn very quickly from the T-square and boards as artists used to start using new gigantic computers that weighed a ton and that she wasn't really familiar with. And she got the support from her employer to kind of do that work. At the same time, my father was in the publishing side involving books in paper and glue and cardboard, and it was a very different trajectory. And I watched as that skill set changed rapidly. And it changed rapidly over a period of, maybe 5 or 6 years where there was no longer a need for typesetters. And there was no longer a need for that kind of work. And the lack of support, and at least in my estimation, was a big part for why he wound up more or less having his career end, and not in a way that one would like. And so I think about how technology impacts employment, how it impacts the viability of individuals in the workplace on a very personal level. And of course, we've seen the internet, right now we're talking about AI, but we've seen the internet make enormous changes as well. I'm an amateur drummer, and please, amateur is probably putting it nicely. But I took drum lessons as I was a junior associate in Manhattan. I found a half hour somehow to do that from time to time. And the guy who I went to said to me directly, you know what, just FYI, since because I'm an IP and entertainment lawyer at the time, he said, by the way, my entire side gig, right, all of the jingles and the stuff that I play for commercials, it's all going away with drum machines. Right, and this is 25 years ago. So I take that perspective on it when I think about the impact of technology on individuals rather than at the macro level.
Okay, great, thank you. And I know that has been a very personal journey for you. One that's and one thing to say that to be clear, what we are saying is that specific predictions about labor markets and jobs are usually wrong, but we're not saying that impacts on labor markets and job displacements do not happen. That is, all the evidence shows that does happen, which is hard to predict ahead of time. So even if specific predictions about job loss turn out to be wrong, people do just get displaced and lose jobs, whether from technology, macroeconomic shifts, or global trade. So what do you think we should be doing about that? Are we doing enough as a society to deal with situations when suddenly someone's livelihood is made obsolete?
I mean, the short answer is no. I mean, I look at the Daniels Fund Ethics Initiative and I think, well, there's a good framework for guardrails around implementing technology, right? And you start with integrity. And I'm not going to go down this list and use it as a checkpoint, but I'll put it this way. What we have clearly right now, without question, is a gold rush. And it's an understandable gold rush because the technology is cataclysmic. It creates content in a way that the internet didn't. It does things that, as Harry, who's the expert on the computer science of things, would say, even a few years ago, you didn't expect it was capable of doing. And so it stands to reason, particularly where, as Harry alluded to, my focus is often in trade secrecy, where first to market is the winner, one would expect that we're going to see AI purported solutions to everything. The challenge associated with deploying AI in that way is that, in my estimation, we are focusing very, very, very heavily on the short-term gains involved with being first to market and less about thoughtful deployment. Now, I'm not suggesting that there aren't ways to move quickly, and I'm certainly not opposed to people having success in the startup space. But the gold rush aspect of this means that I think we're putting a lot of situations and concerns aside. More often than not, when I hear people in industry speak about AI, it tends to be 40 minutes of discussion saying how great it is. And then we say, oh, by the way, there might be existential threats and we might have to deal with hallucinations. And maybe there's these problems and we'll get to those later, which is understandable. But of course, that is not the way even that the internet was deployed. We had a lot more time with the internet. And of course, the values inculcated in it, at least initially, gave us the time to think creatively about how we might deal with the downsides of the technology. Not that we did well in all cases, and not that we could have done better. So at the top level, when I think about the honesty, and this is why I'm here to talk about these things and to work with my old friend and colleague, Harry, is to have an honest discussion about what the opportunities are, what the risks are, recognizing that we don't have a crystal ball. And because we don't have a crystal ball, we can only make the best decisions based upon truth and evidence. I'm not sure that we're doing that yet, although forces that we might talk about could push us in that direction.
Okay, great. Thank you for that thoughtful answer. So we talked about how economics tells us that technology can complement and it can supplement. So on the optimistic side, where are we seeing technology, AI, complementing legal practice today?
Yeah, so I look at it this way, we have to draw a distinction, as Harry alluded to, between the skills necessary for a job versus, for example, how many jobs we need or how many lawyers are going to do the work. So I can think about it at a very fundamental level. Fundamentally, I think about it first from the perspective of something like access to justice. When I was a litigator for about 8 or 9 years, and I would deal with pro se plaintiffs from time to time because I was at New York City Corp Counsel, and I think about the complaints that these individuals who did not have attorneys drafted. The lawyers or law students in the room would understand that I made motions for more definite statement, right? Which is a motion for the non-lawyers in the room that says to the plaintiff, basically, I don't know what you're saying. Please write this in a more clear way. And I had judges tell me, and this was in the Southern and Eastern District of New York, more than one say, counsel, you and I both know that this pro se plaintiff is not going to write this any better than the pro se plaintiff has already. Motion denied. You go back to your office and write the answer to the complaint that you don't understand. Now, literally. And it made, at first I thought, my God, what kind of ruling is that? But it made a lot of sense. Well, let's be clear. Certainly lawyers are not relying at this point on generative AI to draft complaints. At least I hope they're not, right? But for the pro se plaintiff who would lack the skill or the opportunity or the education, not to mention the resources potentially to have a lawyer, my God, is this an improvement? And so access to justice to me seems to be an enormous benefit of the technology. Additionally, it makes lawyers without question more productive. When I was a junior associate, I did the late 90s, early 2000 version of generative AI. I would call up Lexis and Westless researchers, right, who were on the telephone at 1-800 numbers. I would ask them to research a legal question for me while I drafted something else. Since we're talking about ethics, I billed one client. I want to be clear, I was not double billing, but that was an example of where I could have used resources. Now, again, the initial drafts of documents, certainly the kind of mundane, frankly, as the dean referred to, and repetitive tasks, AI are doing pretty well. And I think that's where we can complement attorneys to have attorneys doing the more thoughtful, the more relational, and the more robust work. On the downside, the fundamental question to me, again, I don't have any more answers than Harry does. I flew here across the country to also offer you uncertainty, is the question of how many lawyers we might need to do some of these tasks. And I think that's a little bit different question.
Yeah, exactly. Well, thank you for that. Yeah, so we're seeing today AI having some complementary effects in terms of answering legal questions, both basic legal questions for pro bono folks out there in the world. It's actually a huge benefit. So we always think about what's the next best option. So ideally, every pro bono pro se client would want to have a lawyer. But of course, pro se clients don't have lawyers, so all the time. So the next best option is always what can they do? So often they're going to Google, they're asking their friends, their trusted family members, and AI offers another solution towards giving them at least better than their next alternative. And as you said, when it comes to lawyers, lawyers are using it to draft a range of documents, but we're hoping that they are learning best practices in terms of double checking citations and facts and things of that nature.
And certainly courts are becoming more or less completely impatient with lawyers that don't.
Yes. So when we, do you see any role for professional organizations or universities or other institutions in shaping the direction of AI and employment? So we can see we're not just passive recipients of our future, right? We think our government and our institutions can nudge us down a path where, maybe technology is complementing and causing people to thrive, or maybe there's another path where fewer people are thriving. So what do you think the role of institutions is in that future?
So that's also a really important question. The cliche about the law and institutions not moving fast enough for technology generally is true. I don't think there's any question about that. However, the thoughtful setting of what Victor Mayer-Schomburger and Urs Gasser call guardrails is where institutions can be quite powerful, right? The ABA, of course, is vilified by many, right, in terms of the barriers to entry that it creates to the profession. At the same time, it helps create the self-policing that is at the essence of what this profession does, right? Setting the standard for law in particular that moves it back to being a calling and less of a profession in traditional sense, I think is critically important now. I've done a lot of thinking. In fact, I'll probably do more writing on the decline of professionalism generally, right, in a variety of spaces. And it starts with the fact that institutions play a role beyond just cheerleading their constituencies, right? They set the bar for what schools do, right? Colorado is an example of a law school that sets the bar for lots of other law schools. And so do other schools in other regions set those standards. So step one is really being the place that allows for the discussion of guardrails. Secondly, and I think equally importantly, it's setting the standards for what it means to be an attorney. We talk about this. I teach 1Ls and upper level students. I teach contracts. I teach intellectual property, a variety of courses. And whenever I'm doing that, I'm modeling, right, the kinds of behaviors that we would expect professionals to engage in. I tend to be rather traditional in a lot of ways. I call my students Mr., Miss, they, right? They call me Professor Levine. It's not ego stroking, although probably it's certainly nice to be called professor from time to time. But the point is, it sets standards for what it is to be a person that has the power that attorneys do. Right. The first time that I answered a question for a partner as a summer associate, and the partner said, "Okay, there's the answer," and picked up the phone, it was that long ago, to call a client, I thought, "Oh my God, I hope I got it right." Right. And I fortunately I did, sort of. And those kinds, that was my first answer. And those were the kinds of moments where I thought the power of this profession is one that requires me to think carefully. Again, I'm going to use it again. These kinds of standards across the board. Can you meet those standards in all instances? Unfortunately not, but striving to do it is essential, and that's where institutions kick in. And so I'll stop there because we can talk about lawmaking in those institutions as well.
Yeah, I firmly agree with you that our institutions, our government, our professional societies, our universities have both the opportunity and the obligation to nudge us down the path to a future where more of us are thriving, and the opportunity is now. We can all make those decisions, whether it's in how we use technology or how we advocate technology in a way that helps more of us.
Yeah, and I'll just jump in on that. I mean, the dean was talking about the rule of law, which is obviously a challenge right now in our country. And Mark Lemley, when he was on my Hearsay Culture radio show at Stanford a few months ago, talked about institutions standing basically for truth, standing for truth. Now, that at one time might have been a low bar, but it's an important bar now. And so merely having the kind of honest conversation about the pros and cons of a given issue without calling each other names, without belittling people for lack of knowledge, which again should not be the high ideal, but maybe it is now, is the essence of what we need in order to implement this technology in a way that doesn't create the kinds of harms that Senator Sanders and others have talked about. As you pointed out, Harry, there's no question that we don't know, which means there are downside risks. But without having honest conversations across a multitude of stakeholders, I'm going to keep referring to that banner, right? We're not going to be able to have those kinds of conversations and won't get the leadership.
Yeah, absolutely. And I really like your point about role models, institutions and how they act and what they say serve as role models for society about norms and what can help all of us thrive. Okay, in our last 10 minutes, I want to open it up to the audience for questions. We have a tradition where we often look to a student for the first question. So is there a student? Yes.
I'll wait for the mic since Max
That's all
works
mic,
really
sorry.
hard. So thank you both for being here. I work part-time in a congressional office, and I've found that I'm getting a lot more messages that people have used AI to type up, or AI. And sometimes it's like overwhelming because now they can, instead of typing, a few sentences that I would have to maybe make sense of, now it's pages and pages. And it's overwhelming for me, and I've got to go through and sort through all this. Most of it's not even relevant to what they're asking for. What happens when pro se plaintiffs and other people find this and use it to make pleadings to the court? The court system could be overwhelmed. Like, how do we avoid that? And are we taking any actions right now to stop that? I mean, we want access to justice, but I don't think we have the infrastructure for it. So what are your thoughts?
So that's a great question. And as a legislative staffer from about 30 years ago, you have my sympathy. What you're referring to, and you didn't say it because you work for a member of Congress, I'll say it since I don't. You talk about AI slop, unfortunately, in a lot of ways, and noise that is put into the system that more or less, other than tallying how many of those messages you get, can often be not helpful. And to be clear, there's a difference between input that is valuable for policymaking and making your voice heard. I am all for making your voice heard, but that's a fundamental difference than offering policy subscriptions and so forth, which you may not easily do through AI and just have it write something. Courts similarly can be flooded. I'm not sure that we necessarily have an increased risk of pro se filings, given the number of pro se filings that already exist. I do think that there is certainly the risk that, given the stress that state court systems in particular face in these scenarios, that we could see, and I don't think we're there yet, where AI is creating the kind of noise within the filing system that would overwhelm it. I do think clerks, right, just as you're describing as a staffer, have to weed through those materials. I don't think that courts are at the point yet where they're thinking about how to create filters, if you were, for preventing the kinds of frivolous filings that would otherwise be handled by Rule 11 and Rule 37 and so forth. But I do think that courts are, because they're implementing local rules with regard to the use of AI, are preventing the kind of abusive use of AI where you're filing something, or as I alluded to earlier, where you don't know what the citations are, or where you're filing claims that simply lack merit. We still have our motion system to prevent it. So that's my long answer, as a law professor does. The short answer is we're not there yet, but I would refer you to Lorelei Kelly's work from Georgetown, who's written on resilient government and has this amazing concept and idea of doing local field hearings as a way to deal with the input issues in a more meaningful way. And I'm happy to talk about that as well offline. It's a great question.
Yeah, and I loved your answer. And just from a theoretical perspective, we've seen whenever technology lowers technological transaction costs, it has some benefits. So now some people who couldn't express their views because they weren't good writers or didn't know how to express their views eloquently now have a voice through AI to express their views coherently, and that's a positive. But also it creates trade-offs, right? So now people can increase the noise to signal ratio, something we've seen in the past with email spam and things of that nature. And probably at some point, the resilient institutions will have to adapt the rules from 2000 or 1990. Need to change in 2025, given the shifting technological landscape. So great. Another question. Doesn't have to be a student these days. I've seen this guy back there.
Yeah, please wait for the mic. We don't need it. I said that before. Thanks.
First of all, thanks for super stimulating talk. And especially the distinction between task versus job is an interesting one to think through. I'm wondering, do you have a taxonomy or a typology of legal task? And it seems to me that what has changed is the ability of AI to complete more complex, sophisticated tasks. And that feels like the threshold that I think we see something different here. Do you have is there a taxonomy or a typology out there, and how might we think about certain tasks that are going to be completed soon by AI?
Yeah, so we do have this, and one of the real subtleties is when AI gets you from 0 to 80% of a task, which can actually be a complementary and can actually help you and lead to great productivity, versus if it ever crosses that threshold of completely substituting for the task. And those gradients are subtle. So in the case of really complex tasks, the AI, it might superficially seem like the AI is doing the whole task, but maybe it needs the human lawyer to get it across the next 10%. In that case, it's actually can be a great boon, because it means the AI lawyer can do more, AI-enabled lawyer can do more complex tasks, more of it, provide more value. But in certain tasks, and we've seen this in e-discovery is the best example of this. The dean was talking about this. Poor associates used to sit in windowless offices, and their task was to search for text in documents. It turns out that AI is better than that and humans. And so that is substituted largely for that task. You need many fewer people to do that same amount of task. And then sometimes that frees up labor to other value added tasks. So that's what happened to associates. There was sort of the prediction around 2010. They made the same syllogism that we saw. AI is better than humans at searching through text. Associates search through tests, therefore associates will be replaced. But we've already seen that syllogism is too simple, both in terms of the technology, and what wound up happening is it replaced one task, and then associates were redeployed to other tasks where they were valuable. And actually legal employment has increased about 3% a year since 2000.
Yeah, I'll just add very quickly, when I talk to my students about this, I say to them, if you do want to do your best to render yourself obsolete, right? Don't write briefs, right? Don't summarize cases, because that's probably the best current use of AI. But of course, it gets to the things that AI are not doing well, or more importantly, the kinds of things that we might say human beings would not want to rely upon AI to do, right? The relational aspects of the law, the nuance, the new arguments. I mean, Harry, you've talked about the circuit split involving the Third Amendment analysis, right? The lack of data, right? That from which an AI can draw a conclusion. And so that's where the for lack of a better phrase, the fun aspects, if you will, of law are still not the things that AI tends to do as well as humans, not that it will never get to that point, but the concern about job loss to me comes back to the basic idea of why are you in class in the first place? If you're not here to build your skills, right, then you're in the wrong profession. And if you want to, now I use this argument for making sure my students write briefs, and if you want to run yourself obsolete, please don't write briefs, book brief, or ignore the briefs altogether, and then we'll see where you are in the future.
All right, last question, real quick. Yes,
Mike.
and then we're gonna take a break after this.
Thank you. So lawyers have an ethical obligation to represent their clients well, and they also have an obligation to represent them efficiently. So I'm curious if you have lawyers coming to you asking for advice with how to balance these two obligations in the age of AI, what do you give them?
So there are, as a general matter, right, basic ethics requirements, across the states, right, require that you at least have some basic understanding of the technology that you're using, right? It wasn't long ago that there was a discussion of lawyers having to be coders. Now, I never bought that to begin with, but certainly that would seem not to be the case. So having a basic understanding of what the technology is would seem to be the floor. Now, the question, of course, as to what happens to the data that you share with an LLM is a whole related question, and it gets to trade secret issues, and I will go on forever. So I'll simply say that the risks associated with putting any information into a model that you don't control, right? I'm not talking about the walled gardens that firms might build, but ChatGPT is an enormous ethical quandary. And we saw very early on, even a couple of years ago, that large entities like Amazon and Samsung were finding that their proprietary data were coming out as responses to queries because employees were sharing it. So controlling information, cybersecurity is always essential. The balance, of course, right, and it seems to be the case, firms are not generally passing off the cost of AI, right, in terms of efficiencies to clients, right? They're doing work faster, and clients more or less expect, at least the bigger firms, to be using AI that way. To the extent, therefore, that you're a solo or smaller practice, I start getting a little nervous, right? If you have a large firm which already has, although they might charge more, right, have the scale to handle something a lot faster or just throw dozens of associates at it, right? You could run into a situation where the small or medium-sized practice has a challenge of competing with a firm that now has its own walled garden on top of the resources. I think the countervailing aspect of that, as Harry was alluding to, is that the knowledgeable, skilled attorney armed with AI that they know how to use, right, and that they're using ethically, could actually wind up, perhaps exceeding those skills to the extent that the relations are important. So that's kind of my short answer in the interest of time.
Yeah, and I agree with that. One idea I throw out there is have the mental model of the AI system that you're using for law as the best third-year law student in the country, the number one. So if you hire the best third-year law student in the country, no lawyer would take their draft written by the third-year law student and give it directly to a judge or a client. Rather, you would take it as a very good starting point, and you would double-check the characterization of the case, the statement of the law, all sorts of things. So if you treat AI like that, and you double-check and you triple-check, that's a way you can use it ethically, making sure that everything is there, it's accurate, but also recognizing that it can be useful. So we are out of time, so please join me in thanking Dave Levine for being here. We have a break now, and we will be returning at 55 for our next panel, which will be even more informative.